Hi, folks. Welcome to the latest episode of the Positive Change webinar. Today we are talking about how to tackle hate crime and protect our people. The webinar is brought to you in partnership with the Irish Network Against Racism. I'd like to thank everyone there, especially Shane O'Curry and Lucy Michaels and all the team for helping us get here today. My name is Hazel Chu. I am the Lord Mayor of Dublin City. I'm the 352nd Lord Mayor of Dublin City, and this morning I'm delighted to welcome you to discuss the issues of hate crime in Ireland, ask what kind of legislation we need to put in place, and discuss the incoming legislation on the matter. Because unfortunately, as many of you know, watching this webinar, you may have known someone or you may be yourself someone who have been a victim of hate crime. I know many people suffer it. I know my family do, and I know many people who have suffered racial abuse are too scared to come forward as well. So Ireland currently does not have any specific legislation to deal with hate crime. At the moment, the only legislation in place is the Prohibition of Incitement to Hatred Act, the 1989 Act. Thankfully, this is soon going to be changed, as the Department of Justice is due to publish a new hate crime bill later this year. But what will this new hate crime bill look like, and how will it affect victims of hate crime, and how does it compare to other hate crime laws in other jurisdictions? This is what we're going to be talking today, and how will it ultimately stop hate crime in future? So we're going to have a very open discussion with our panelists today. We're going to be also bringing in some of your questions as well, and we may bring in some people who would like to ask questions live at the end as well. So new research has been published recently by INAR, which is the Irish Network Against Racism, and it shows that we are on a record high of 700 racist incidences that has been reported. This comes up from 530 from the year before. So it is here, folks. And the question is, what are we going to do about it? And this is why we're having sessions like these today. And this is the amount of incidences that are reported. There are many that will go unreported because people who are too terrified or people do not know how the reporting happens. So in this morning session, we're going to discuss the incoming legislation. In the afternoon session, we're going to have guests, including An Garda Síochána, talk about the reporting structures and what are the processes in place. So joining us this morning, I am delighted to welcome Anastasia Crickley, former chairperson of the UN Committee of Elimination of Racial Discrimination. Anastasia will be the moderator for this discussion. And joining us on the panel, we have Ciara Carberry, Principal Officer at the Department of Justice and Equality. And Ciara has been working on this from the very beginning. I had the pleasure of meeting her some 18 months ago. Dr. Seamus Taylor, Head of Applied Social Studies and Lecturer in Social Policy at Maynooth University. Doran Ansbro, Senior Researcher and Policy Officer at the Irish Council for Civil Liberties. Owen de Verdon, Traveller Activist and Board Member of the Irish Network Against Racism. Bashir Otokoya, Assistant Professor in Advanced EU Law at the School of Law and Government of Dublin City University. And Peter Kearns with Independent Living Movement Ireland. Thank you for coming this morning. So just some housekeeping as well. This is going to be a very open and frank discussion. We're going to bring in our guests. They're going to give us their views on the incoming legislation and how it works, and also how we need to do better and what will the structures be in place. But I do ask, an audience can come in, as I said, and their questions will be taken at the end. I do ask people to be respectful. I've always said that this is a subject we need to openly discuss and we need to be transparent about. So I do realize that there are going to be very I guess, divisive views, but I ask people to be respectful insofar when you are coming in to ask questions, to do so respectfully. All questions we will try to answer them. Anything we don't answer today, they will be answered through the website and published on the INAR website. And anything that is abusive, we will not be answering, just so everyone knows. So a little later, we'll be speaking to Bajit Uvai, from Director of Policy and Strategy at the Crown Prosecution Service for England and Wales. She'll be giving us an insight in how the hate crime legislation works in England and Wales. So we're going to be looking at different jurisdictions as well. And without further ado, I'm going to hand over to Anastasia. I really hope that this discussion and getting yourselves involved will build us a better society in future. And I thank you all for coming today to have this discussion with us. Anastasia.
Thank you very much, Lord Mayor, and thank you for your opening remarks. Indeed, I would like to see today very much as a crucial statement of this city's commitment to combating hate crime and to the continued action that will need to be taken in that regard. Hate crime is a crime where the victim is targeted because of a perceived association with a particular identity. It's not new, as the Lord Mayor has said, and indeed the previous legislation to address it, which many of us were associated with and have since campaigned for its enhancement and strengthening of 1989, didn't really do what many of us hoped it would do. This discussion is timely. It's timely because hate crime, now more than ever, is an issue that affects far too many people. But it's also timely because government responses are now being prepared. And I look forward to this morning's discussion with all of the people who will be engaging with us. Without further ado, however, I would like to start our discussion with Ciara Carberry, and in so doing, I would like to commend her for the very hard work that she has undertaken to bring the review that I'm going to be asking her about to fruition and to publication. Recently, Ciara, the government did conduct that review of current legislation and published a report recommending that the new hate crime bill would be developed. Can you tell us what prompted this review and what it actually is telling us, please?
Thank you, Anastasia. And it's great to be here just to say that the response to hate crime and to hate speech in Ireland has to be a really broad response. It has to be a whole of society response. So I'm very conscious that the responsibility of the Department of Justice is the law enforcement response. It is the justice response. But the problem of hate speech and hate crime is much wider than just being a justice problem. And that's why this type of webinar and this type of engagement is so important, because of that need to work together and to come at this problem from a number of different angles. I think the 1989 Act, which prohibited inciting hatred on a number of grounds, it was a pretty good act for its time. It was pretty forward-looking for its time. And in two particular respects, it was very forward-looking. And that was the fact that it did recognize sexual orientation as a trigger for hate speech and hate crime. And it did also recognize that people in the traveling community in Ireland were being targeted and include both of those as protected grounds. But the world has changed enormously since 1989. In one sense, I don't think it has changed in the sense that the problem of hate speech and hate crime has always been here. What has changed maybe is our own recognition and understanding of how much a problem it really is. I lost count of the amount of times people have said to me, but Ireland was monocultural until recently, and that new communities have only sprung up recently in Ireland. But when you think about this in any depth at all, you realize that there have always been marginalized communities in Ireland, whether people were being marginalized because they were gay, perhaps they were being marginalized because they were a traveler. I think we are all very familiar with the treatment that women receive, particularly unmarried women and women who had children outside of marriage. So, but I think our understanding of the size of this problem and the need to look inside ourselves at our own prejudices has changed enormously in the period. So our law needs to be reformed and updated as we learn and as we go. The difficulty, I suppose, with updating the 1989 Act is that it deals with freedom of speech. And restrictions on incitement to hatred are essentially restrictions on how you can communicate about other people. So what the incitement to hatred legislation is designed to do is to say you are not allowed to communicate with about other people in a way that puts those people in harm's way. And one of the big challenges with that is to make sure that the way we interfere in that is proportionate to what we need, you know, and that we don't overstep in terms of restricting people's freedom of expression unduly. So for that reason, I think it's taken us a very long time to come around to coming to some conclusions about it and to bring forward concrete reforms. The other thing, of course, is that has become very obvious is that we have to deal with hate crime as a specific form of crime, which is something we have never done really before. So the new hate crime bill is designed to deal with both of those things.
Thank you. Thank you very much, Ciara. Acknowledging that concern about proportionality and specifically dealing with hate crime, can you give us some details of the kinds of measures that we are likely to see in the new bill, acknowledging also where things are at the moment and that you've just completed the review and we await the bill actually?
Yeah. So I suppose it's worth giving a rundown of what happens next. So we conducted a very broad public consultation last year, and I know that some of the participants in our webinar today contributed really significantly to that consultation and cooperated with us and stood behind us in running it, and that made it very powerful. The report on that was published in December 2020, and the analysis of all of the submissions we received and all of the meetings we had led us to 10 conclusions, which are set out in the report. So the report, if anyone wants to look at it, it's on the Department of Justice website. And it sets out the 10 conclusions we drew from the work we did. We also did a piece of research ourselves, our own research and analysis function, looking at the approach to hate crime legislation in 5 neighbouring jurisdictions in Australia, in Germany, in Sweden, in Canada, and in England and Wales, to see what we could learn from those who have sort of ploughed the furrow ahead of us. And we also ran a series of workshops in cooperation with various groups around the country. Those were facilitated independently, and we pulled all those together. We have our 10 conclusions, and those 10 conclusions are the policies and the principles that will be brought forward into the new hate crime bill. So the work that's been happening since December is that we have been translating, I suppose, the general language in the report that sets out the ideas into the general scheme of a bill. The general scheme of a bill is like the headings, it's like the paragraph headings for what will be in the new law. And that has to be approved by the Minister for Justice, and then it has to be approved by the government. And once that is done, once we have government approval and the government is happy that the bill reflects what the government wants to do on hate crime and hate speech, it will be published. And it then goes forward to the Houses of the Oireachtas. And in the Oireachtas, there is a specialist committee that deals with justice issues. And that committee will examine the general scheme of the hate crime bill very thoroughly. It will seek the views of interested parties. And I hope that that will be an opportunity for really valuable and detailed contributions. And then when the committee has completed that process, the bill will be drafted into legislation by the Parliamentary Council's office, and then it has to be approved by the Dáil and it has to be approved by the Seanad. So that's just to, I suppose, highlight that whatever I say about what we have put into the bill at this point, it can change at any of those points through the process, and we won't really know what the law is as enacted until it reaches the very end. So where we are at the moment is the general scheme is been drafted, it's at an advanced stage. I would expect it will be published in the next maybe 4 weeks or so, and then it will be out there and it will be for pre-legislative scrutiny by the Justice Committee, and there will be an opportunity then at that stage for further input into it.
Yeah, that's very interesting, but I know what people here are concerned about, and it's very useful to have the timetable, is what the contents might be and what the contents, in fact, what sort of contents have been recommended in those 10 conclusions from your review. For example, can you share a little bit about a couple of things, like your thinking to treat, your decision to treat hate crime and incitement in a single bill, a little bit about how you envisage the legislation will determine the test or for the hate element in a hate crime, and a little bit about the groups of people you envisage that will be protected under the bill. And my apologies for asking them all at the same time, but I'm a little bit conscious of the time that we have for your direct part of the discussion just now.
So I think as part of our consultation, we spoke to people working in law enforcement, we spoke to people prosecuting hate offences, and we spoke to communities. And what came across very strongly is that the people who experience hate speech and the people who experience hate crime are often the same people. The impact is happening in the same places, and incitement to hatred happens in the same sphere of experience as hate crime. So that was behind our decision to treat them both together. I know that we consulted with An Garda Síochána in relation to what is workable for them and prosecutors, and their feeling was that it was useful to have all of these hate-based offences in a single piece of really clear legislation where it could be accessed all together and where the way that it interacts can be seen. So the new hate crime bill at the moment, as it is structured and subject to all of the approvals I've mentioned, will contain, broadly speaking, 2 incitement offences. The first one is actually inciting hatred yourself. So where you deliberately set out to incite hatred against somebody because you associate them with a protected characteristic, or where you're reckless about it. And reckless in this context has a really specific meaning in criminal law. It means that you knew that what you were about to do was significantly, that there was a significant risk it would incite hatred against these people, and you went ahead anyway. So this isn't something you can stumble into by accident. You have to either set out with that purpose in mind or have thought about it consciously, know that it's significantly likely to incite hatred, and gone ahead in any case. So that's the primary incitement offence, if you like. Then we do need to deal with people spreading hateful material as well, and that came across very strongly. So whether you're spreading it on the internet, or whether you're going around putting leaflets through people's doors or sticking notices on flagpoles, there's lots of ways of doing it, and there'll be a second offence in there to deal with people who are distributing material inciting hatred. The rest of the bill will deal with, it will create specific aggravated forms of existing offences where those offences are motivated by prejudice against a protected characteristic. So what the approach we took there was we listened to people very carefully about the types of offences that tend to occur in this world of hate, I suppose, and they tend to be offences against the person. So an assault, or harassing somebody, or graffiti, criminal damage, or public order type offences. So for those offences, we've created, or we intend to create, a new form of the offence where it's motivated by prejudice. So you will be charged with a specific hate form of the offence, prosecuted for that, and if you are convicted, it will be recorded in the record of the conviction that that was a hate crime. Then there will be a sort of mop-up provision, I think, for other offences that aren't normally hate crimes, but that could be. And for those offences, what we would like to see is that the fact that the crime was aggravated by prejudice will be, must be taken into account at sentencing as an aggravated factor, and must be placed on the formal record, so that when that person goes through into, or maybe they're being managed in prison, maybe they're being managed by the probation service, maybe they've gone through and served their time and come out the other end and are on parole, that information that this person has committed a hate crime in the past will be available to the people who are responsible for managing the risk associated with that person, whether that's in prison or elsewhere. So the types of offences I'm thinking about there, where there isn't a specific new form of the offence, maybe might be things like burglary or fraud or something, where generally speaking, they don't show up as hate crimes, but it's not impossible that they would, and we need to have a way of dealing with that. So that's what's in it in relation to hate speech and hate crime broadly. I hope that answers. And then in relation to the protected groups, sorry, I just realized I didn't answer you there. There are the list of groups in the 1989 Act is a really good list, but we saw very clear evidence during the consultation that there are a couple of things missing. Firstly, ethnicity of travellers is treated differently to other ethnicities in that it's given a sort of subcategory of its own in the list. And really, we felt that the ethnicity of travellers should be treated in the same way as all of the other major ethnicities and brought into the main definition. So we intend to do that. The second thing is that disability needs to be added as a protected characteristic, and there was very clear evidence of that in the consultation. And the third thing is that gender needs to be added as well. There was lots of discussion around other things. People thought maybe employment status, homelessness, postcode, accent, social class, all of these things were raised and discussed and examined. But the two that met the threshold really, I suppose, for adding in terms of evidence were gender and disability. We have to be careful with criminal law because you have to be so precise and so minimalist, if you like, in your approach. You can only add in the things that are absolutely necessary and proportionate.
Okay. Yeah. Now, I'm very conscious of the time, and of course it was inevitable that you would have to add travellers in the way that you did, given the recognition by the Taoiseach in the Dáil on the 1st of March 2017 of travellers as a minority ethnic group. But very briefly, and I'm conscious we're a bit over your time, which will have implications for the others, could you tell me a little bit about how you envisage the legislation will determine the test for the hate element of a crime?
So one of the advantages of having the hate built into the offence from the beginning is that the fact that it was a hate crime will have to be proved in court. So there are advantages on the side, I suppose, of those who would wish to see hate crime prosecuted effectively and everything else, but also for the defendant. If someone is going to be convicted of a hate crime, it is fairer that that should have to be proved in court. So that will have to be presented to the jury, and the jury will have to be satisfied beyond a reasonable doubt that the crime was motivated by prejudice. As a safety net, there will be an alternative verdict available to the jury. So where the jury finds that it hasn't been proven beyond a reasonable doubt that the offence was a hate crime, there will be a power there for the jury to find them guilty, or the court, if it's the district court, to find them guilty of the ordinary form of the offence. So that's a safety net or a balancing measure. But we will have to try and provide some guidance for juries and for courts in determining whether an offence was actually motivated by prejudice. And we're looking to ODIHR have a good list of bias indicators that they are working with us on in terms of how they apply to legislation. But they're used in reporting, they're used in investigation. There's a list of about 10 of them, and none of them on its own is enough to say something was a hate crime. But if you have 5 or 6 of them present, that's quite a strong indication that there was a hate element to the crime. So things like if the person demonstrated hostility toward a protected characteristic immediately before, during, or after, if the person had previously a pattern of crimes against this type of person, if there are significant cultural differences between the offender and the victim, if all the witnesses to the crime thought it was a hate crime, if, there are lots of them and they're available. People can look them up if they wish. Yeah, so what we're looking for is that the motivation has to be proved to be prejudice, but that there are demonstrative aspects to it that can be used by the jury to inform their decision on whether it was or it wasn't a hate crime.
Thank you very much, Ciara. I know these are issues that we will be coming back to during the morning. My apologies to have to cut you short, but I'd like now to move on to Seamus Taylor. Seamus, I know that your previous work, your research and your ongoing commitment is are all very closely associated with addressing hate crime. And maybe the first question I'd like to ask you is, what principles, having listened to Ciara and having considered where we've gotten to now in Ireland, what principles do you think should inform the upcoming hate crime law? What starting points and principles? I can't hear you. Sorry, I can hear you now, Grant, yeah. No.
Simon, Graham?
Ask him to unplug his headset.
You need to unplug your headset, I'm told, Seamus. Sorry about that.
Also, can you acknowledge that there's some questions up on the board here?
And I'm hearing that there are some questions up on the board as well. So I'm looking forward to a lively discussion later. Seamus, I think they're telling me that you need to unplug your headset. And I don't know if you can hear me, it gets to be the problem.
Anastasia, will you?
Civil liberties.
Hello.
Ciara,
Can you hear me?
we can hear you now, Seamus. I was just about to go to Darren in front of you, but now that we have you, we'll revert to you again.
Yeah, I think it obviously something went wrong with the headset, so I've taken it off.
Never mind. Let's go directly with the questions to you. These things happen for all of us on this occasion. I acknowledged at the outset the commitment that you've shown personally through your work long before you returned to Ireland, and in the work that you've undertaken since you came back, the commitments you've undertaken, and also your research, your commitment to addressing hate crime in a variety of areas. But what I'd like to ask you first is, what principles at this point in time, and having heard from Ciara about the review that's been undertaken, what principles do you think should inform this upcoming hate crime legislation, Seamus?
Okay, thank you very much, Anastasia, and thank you, Ciara, for what was very helpful contextualization of where we're at the moment. In terms of principles that I think should inform us going forward in this area, any legislation should be proportionate to a legitimate aim. That's a fundamental starting point. I think it should be inclusive of core identities that experience discrimination. I think it should offer parity of protection across strands. There shouldn't be a hierarchy of victims where some are protected more than others. It should hold public confidence, and it should hold the confidence of victims, suspects, and society more widely. It should deliver justice for all. It should deliver justice for victims, suspects, and society. An important thing, I think, is that the law should seek to accommodate the difference principle in equality. Not all the forms of discrimination manifest in the same way. So what is anti-traveller racism doesn't manifest in the same way as anti-disability discrimination. And I think we should try to have a sufficiently nuanced response that we're able to accommodate some of those differences. We have that already in disability law, where you have the concept of a reasonable accommodation. So we might have to address some of the issues and manifestations of hate crime differently in order to, at the end, treat them fairly and equitably. I think any law should be based on need, not numbers. When I worked at the DPP's office in London, we had very few numbers of gender identity-based hate crimes, but we had very high need in that area, in that some of the most violent hate crimes were perpetrated against transgender people. I think that any law must be evidence-based. Any provisions and inclusion for protection should be based on evidence wherever that is available. I think the law should be clear, it should be workable, and it should be effective. Workable, I mean that it should be possible for the guards to investigate a case. Effective, meaning that it should be prosecutable and possible for lawyers to build a case, and it should be possible to be considered in an appropriate way in a court of law by a judge, and that it should deliver justice for all involved. Now, it may be that any of us might disagree with how an individual case is handled, but overall, the system of handling hate crime must hold our confidence overall. We might disagree on the particulars of one case, but we should agree that the hate crime system is working overall. They're the principles that I think should be applied.
Thank you, Seamus. And do you think the new hate crime bill, as envisaged and as we've been discussing, will adequately protect groups?
Okay, thank you for that, Anastasia. I mean, obviously, we're dependent on what we've read in the document from December, and we're dependent on listening to Ciara this morning. So as Ciara said, it's caveated by what ministers decide as it goes through. But based on what's been said today, there are a number of positive features. I think the fact that it's going to be one overall bill is very good. I think the fact that it's going to have named aggravated offences is very good. I think the fact that it's going to have the mop-up clause, for want of a better phrase, is a very good feature. I think the test of recklessness that's proposed on the incitement side is appropriate and good. That said, I think there are three key things that strike me need to be addressed to improve on what's proposed. The first is the test of proof as to what will constitute proof in a hate crime case. The second is the list of offences that are going to be named as aggravated offences. And the third is some specific issues in relation to disability. So if I take them one by one, the first issue, the test of proof, if I understand it correctly, the test of proof is going to rely on proving motivation. Now, motivation means getting into the head of the suspect and determining what motivated them. And the document that came out from the Department of Justice in December acknowledged that that is a very difficult thing to do, and that unless there are other measures introduced, we risk having unsuccessful hate crime law. Now, Ciara has this morning mentioned work that's underway with ODIR to look at bias indicators. I actually think there's a very simple and practical way through this challenge, and that is just to look to our neighbours in England and Wales who have had a motivation test to prove hate crime, but they have it accompanied by a demonstration test, so that a hate crime can be proven either by a test of motivation and or demonstration at or around the time of offending. And obviously it involves the commission of a base criminal offence like racially aggravated assault, but then that the demonstration could be the use of racial slurs at or around the time of the offence. I'll give you a very clear example of this that I found in my PhD research. It was two disabled men who frequented a community centre in a north of London or a North England city. One used a motorised chair to get around, and the other used a walking aid. Some days in the week, they would go to the community centre and partake in group activities. Some days they would just meet for a chat in the city centre and a coffee. One day they were meeting in a square in the city centre and having a chat, and they were talking away, and they saw somebody coming towards them on a bike and seemed to be cycling directly into them. And they were thrown by this. And as the person cycled closer towards them, the person gathered a deep spit in their mouth and spat it from his mouth, landed it on the man in the motorized wheelchair on the face, and shouted and sped off on the bike. There was the witness, his friend sitting beside him, and there were other people in the vicinity because it was a public square in this city centre. The case went to court. The people were absolutely shocked at what had happened. They were situationally vulnerable because they couldn't respond. It went to court, but the suspect, the defendant, tried to mount a defence to say he was cycling in the city centre and that the sun got in his eyes and it caused him to spit and to sneeze. And that's why he landed the spit on the man. But it was the evidence of the use of the disability slur, excuse my language in repeating it now, that nailed the offence and placed it beyond reasonable doubt for the judge. Now, that's an example of a case. If we're going to go ahead in Ireland without that provision, then we may risk less effective law or ineffective law. So I think, why go into this elaborate system of bias indicators that we'd have to draw on from ODIHR, where it would require 5 or 6 of them, when there's a very, very simple mechanism it exists in our neighboring jurisdiction that we can draw upon. And the other thing I would say linked to that is that the law has been in operation in Britain for 17 plus years. It's been proportionate in the number of cases. The hate crime outcomes for all categories of hate crime are the same as regular crime now, except disability, which lags behind by 12 to 15%. But the outcome for regular assault and for racially aggravated assault, they're both in the early 80%. And they also are similar for the level of guilty pleas. So it's not like the law in Britain is some liberal loose-ended law that's mopping up all sorts of casual racial epithets. Not at all. It's proportionate and it's in line with wider criminal law. So that's on that issue. The next issue is the named offences. Ciara listed the offences that are proposed at the moment in Ireland. I agree with all of them, but the offences that are to be aggravated, you know, like racially aggravated public order, racially aggravated criminal assault, they should reflect the principal offence categories that impact different groups. So it actually, the evidence, the monitoring from the DPP's office in London shows that criminal damage is greater in the religion area than in others, because often it's faith buildings, a mosque or a synagogue that's damaged. It shows that theft, fraud, robbery are greater in the disability area. It shows that particular stalking and harassment are increased in gender identity and in disability, and sexual offences are enhanced in the disability area. So I think before the list of aggravated offences is finally settled, we should look at the available evidence of what are the principal offence categories that are manifesting for the different protected groups. And the third and final area was, I believe that in disability, there is a particular set of issues that need to be considered. I think this is being considered currently by the Law Commission in England and Wales, that the success in the disability hate crime area in Britain lags significantly behind the other strands of hate crime. And the reason being that these cases are often classified as attack on a vulnerable victim or a senseless crime against a vulnerable victim. And what you're finding is that serious crimes up to and including murder are not classified as hate crime because they're classified as targeting a vulnerable victim. Now, I believe that in order to address the specific issues on the disability side, I believe you need the test of motivation. I believe you need the demonstration test. And I believe that we should also be considering discriminatory selection, that somebody is selected for the crime because of the characteristic. And that is a position favoured by the prosecution service in England and Wales, and it's favoured by leading scholars like Mark Walters. I would actually argue that if we have time for a full and open debate on this issue, it should be considered as a mechanism that should be open to all the protected groups, because people are selected because of who they are and the identity that they have. They're the three main concerns. Thank you.
I'm very sorry, Seamus, that I can't continue longer with you, because you've raised really important concerns, not least of which is that there's more work for all of us, and by that I think you meant everybody who is present at this webinar, as well as the state, to do in order to ensure that the legislation is the best possible. I'd like to move on though right now to Darren Ansborough. Darren, who's Senior Researcher and Policy Officer at the Irish Council for Civil Liberties, and in doing so I would like to commend you for the work that you have done on freedom of expression and on the protection of civil liberties, particularly during the last year in very difficult circumstances. But what the question I'd like to ask you just now is, from your point of view, from the ICCL's point of view, what questions do you think are at stake in the balancing of rights between protecting particular groups of people from bias-motivated events and crimes on one hand, and violence on one hand, and the other rights, such as freedom of expression or conscience, on the other hand?
Thanks, Anastasia, and it's great to be here today. Thank you to all the previous speakers as well. It's been very interesting so far. I think from the ICCL's perspective, it's very important to draw a distinction between the two different things that this legislation is going to do. On the one hand, for the first time in Ireland, we're going to have a statutory basis for recognising hate motivation in crimes. And this legislation, and that's much of what Seamus has been addressing, this legislation is effectively going to be recognising that where we have criminal behaviour that's already criminalised under our law, like assault, like criminal damage, we're going to have now a recognition in the law that there is an aggravated form of that offence when it's motivated by hate. And this mop-up offence that they're referring to, just to recap, is about recognising in the sentence that the crime is a worse crime that causes more harm because it's been motivated by hate. And from the ICCL's perspective, we recognise on the one hand there is of course there's the right to equality, the prohibition of non-discrimination. There's obligations on the government to counter discrimination and to counter prejudice under our international human rights law. So there is a need to recognise this, in particular because of what we now recognise as the fact that hate crimes are message crimes. They're often crimes that are directed not just at an individual, but against a larger group. So we are supportive of this move towards creating a statutory basis of recognising hate crime. But we also think there's a lot of different questions to be answered in relation to the hate crime legislation. And I'm going to return to that, if I can, Anastasia, in a moment. The other thing that the legislation is going to do is update existing legislation. So when we talk about hate speech and criminalising hate speech, we have to recognise that we actually already do in this 1989 legislation called the Prohibition of Incitement to Hatred Act. But when we're talking about updating it, and one of the reasons people are saying we need to update it is because there haven't been a lot of prosecutions, and we actually need to understand a little bit more why there haven't been effective prosecutions. We need to understand, is this, some of the research that ICCL has done in the past suggests that one of the reasons is that there hasn't been effective training, for example, for Gardaí and for prosecutors and for judges to understand what that legislation as it exists today does. So we would be saying, we need to approach updating this legislation with a lot of caution, because if you are trying to expand what it does, and what it does currently is it criminalizes speech or distribution of messaging that is harmful, that is threatening, abusive, or insulting, and also is likely to stir up hatred. So we have that in our law already. And if we are going to expand it, we need to understand that any time we are criminalizing speech, or in this case, we may be, expanding the reach of this idea of criminalizing hate speech. We have to understand that the starting point has to be the right in a democratic society to exchange ideas, to receive and impart information. And that's the idea of freedom of expression. And it's extremely important in a democracy to have that freedom to express views, to have open debates, and to exchange, I suppose, information and opinions. We have a very clear direction from the European Court of Human Rights, for example, that freedom of expression does include the language that might shock or offend or disturb. But of course, we have to understand that there is a threshold here of harm, and where there are certain types of speech that causes significant harm. That's when we are looking at potentially criminalizing it, and we have. The idea from the human rights perspective is that we have different forms of hate speech, that the most extreme forms can be criminalized and in some cases should be criminalized. So for example, one of our international treaties requires us to prohibit by law, for example, incitement to hatred, incitement to hostility and discrimination, and of course, incitement to genocide, incitement to violence, that kind of thing. So we just need to make sure that if we are updating this legislation, we need to understand why the existing legislation doesn't work, and we don't go too far where we are actually risking interfering with a society that can freely exchange ideas and opinions without, of course, causing too much harm. So I suppose that's from the hate speech perspective. That's the challenge, is to very much balance the need to retain an open society where we don't have a chilling effect on speech, but protect people from harm and from, I suppose, discrimination.
Thanks, Darren. And to move on to what you were which was basically my next question to you as well. What are your views on the measures proposed so far in the discussion on the legislation and that are contained in the review and what you've heard this morning, given Ciara's and Seamus's inputs?
Sure. So on the updating, so I'll do it in two parts again. So on the updating of the Prohibition of Incitement to Hatred Act, one thing I think that we agree would be very positive is to expand the protected characteristics, the protected groups, to include, for example, gender, to include people with disabilities. So that's, I think, very positive. In terms of the additional tests of recklessness, I think we need to be careful with that and ensure that that doesn't cast the net too high. We do have to remember there's also a balancing act here with the right to a fair trial, the presumption of innocence, for example. There was some suggestion in the report prepared in December that there might be this idea of a reversal of burden of proof, which would mean that a defendant would have to prove that they weren't motivated by prejudice. And we would be very, very cautious about this, because it's effectively shifting one of the cornerstone principles of our criminal justice system, which is that it is for the prosecutor to prove an offence. So we'd be very, very cautious about any suggestion of that. In terms of expanding what types of speech would be criminal, I think we have to also remember, both Ciara and Seamus have already referred to the fact that any response has to be necessary and proportionate. And so we need to ensure that it is actually necessary to expand the categories of speech that would be considered hate speech. And I think we need to bear in mind that there are already other forms of speech that are criminalized in our law beyond the Prohibition of Incitement to Hatred Act. For example, in the Public Order Act, we have threatening or abusive words can be that seek to cause a breach of the peace, for example. That would be a crime. We also have the crime of harassment. Harassment can also be performed by words. So we already have certain forms of speech that are criminalized. And I think it's important to remember, with this mop-up idea, we might need to come up with another phrase for that, but the idea of essentially what that is that whenever anything occurs, any crime occurs, any behavior occurs that is criminal, and there is a conviction for that crime, if it is motivated by hate, there will be an aggravated sentence. And on the one hand, that's very positive, because it means that you can effectively apply that hate motivation to any criminal behavior in an existing offence. On the other hand, ICCL would be very cautious again about creating legislation that is going to lead to higher prison sentences for people. Because, you know, at the end of the day, what we want to do is change behavior in society. And I think that brings us back to the question of what is effective legislation? How are we actually going to, what does it mean if it's effective? Does it mean that we have a lot of prosecutions, or does it mean that we reduce hate crime and we reduce hate speech in society? And I think that's what's really important. So when we're thinking about sentencing and this aggravated sentencing idea, we need to be also thinking about, you know, not just a higher amount of time in prison, but education, like education in prison or probation service run education programs to assist people to, you know, to understand the harm they've caused and to change their behavior. And I think that's really, really important. And I think we need to take into account restorative justice, for example, which may be appropriate in some cases and not all. The other point that a lot of research has suggested, which is quite concerning, is that we also don't want to create a platform for people who actually want to garner attention to their ideas, like right-wing ideas, for example, by getting conviction, going into court, having the platform of court, and creating this kind of martyrdom by being put in prison for their hate speech. So there's a lot of different elements we need to be very careful about. And, you know, at the end of the day, criminal law has to be a measure of last resort. And I know that Ciara was saying, you know, this is about the legislation, this is about law and the criminal justice response. But I think we always have to remember that countering hate speech and countering hate crime has to be, it requires a whole stream, a whole range of actions from government that they're actually obliged to take under international human rights law. And that includes things like national awareness campaigns, education in schools as well as in prisons, as I mentioned, and codes of conduct, for example, for politicians, because we know that people who are in public office, who already have a lot of public attention, how they speak and, you know, and what they say to the public can have a huge effect, a rippling effect, can almost legitimize certain views. So we need to hold them to a higher standard, not necessarily through the criminal law, but potentially through things like a code of ethics, where people are asked to step aside or step down if they breach internal codes of ethics. So there are a few points. A final point I would make is that these complicated tests that we're talking about and that Seamus has addressed there about, you know, whether a crime would become an offence, or someone will be convicted of a crime based on whether they've done the crime because they've been motivated by prejudice or because they've demonstrated prejudice and that kind of thing. There, you know, we do need to look at a lot of different jurisdictions, and I would highlight that this idea of demonstrating prejudice during the commission of the crime is not used in a lot of jurisdictions. The UK is one of the only ones who do it, and partly that's because you may capture, you know, moments where people are in a height of emotion and, you know, they say something that they, you know, fully regret and don't mean to, but suddenly they're being labeled with that label, and that might have huge effects for the defendant on their, you know, on their job prospects, on their education, on their future. So we just always have to remember that there is a balancing of rights here between freedom of expression, protecting people, of course, against hate speech and hate crime, but also protecting defendants against over-criminalization, which can have an extraordinary negative effect on their lives as well. So caution on all fronts, I think, is where we're coming from. Thanks.
Thank you very much, Darren. And you've answered all of the questions that I intended to ask you and incorporated them into your answers, and raised some very important points as well, including one about the reach of the speech and who actually makes it in terms of hate speech. And I'm just reminded of work that we did when I was chair of CERD on General Recommendation 35 of CERD, which deals with exactly that point, contrasting, you know, speech made by a national politician, for example, in those sorts of circumstances. Now, the Lord Mayor has graciously agreed that she won't speak at this stage, but will hold her thoughts until the end of the session, because we've gone a little bit over, but I think it was really important to hear from all three of you as substantially as we did. So I'm going to move directly on now to the responses. But before I do, just in case anyone is wondering about this oh dear thing, I know when I first engaged with it, I was thinking, what are they talking about? Are they actually addressing me as oh dear or something like that? Oh dear is the Office for Democratic Institutions and Human Rights of the OSCE, which is an amalgamation of participating states from Canada and the USA right across to Russia. They used to say from Vancouver to Vladivostok was where it went in the Northern Hemisphere, which emerged after the so-called Cold War, and which does some very interesting work. And that office does some very interesting work. If you look it up, they do interesting work on hate crime, hate speech, and recording of same. But we're not here to talk about oh dear or any other dear this morning, so let's move on very rapidly to the responses from three people who have been listening carefully, I know, and have lots to say and contribute, and are themselves very directly involved in issues associated with addressing hate crime. So first of all, I'm very glad to ask Owen Dvardun to share with us. And Owen, can I?
Yeah, we're afraid Owen, for some reason, Owen hasn't been able to connect.
Oh, well, I'm just told that Owen hasn't been able to connect for some reason or another. I'm wondering if Bashir Otakoya, Bashir, my friend, are you there? Yes, I can see you. So I'm presuming that you are, and you're actually moving. So that means you're definitely, it's not just your photograph, we're definitely seeing you. So thank you very much, Bashir, for being with us. And just to remind people, Bashir is Assistant Professor of Law in Advanced EU Law, actually, at the School of Law and Government of DCU, Dublin City University. Now, Bashir, and Bashir is also a member of the Anti-Racism Committee, currently charged with oversight of the development of a national action plan on racism. Now, as a legal academic and human rights advocate, which indeed you are, and person of African descent, what do you think hate crime legislation should be able to do to protect people?
Yeah, that's a great question, and thanks for having me in this very important conversation on the future of hate crime legislation in Ireland. And I think it's one that's of urgent necessity, I think is the word I used yesterday, having reviewed the I report that I now published. And unfortunately, it is an intergenerational problem. It's something my parents experienced, I've experienced, and unfortunately something I don't hope my daughter doesn't experience, but I know for a matter of fact that is something that she will experience, and it saddens me to say that, which is why I'm so hugely involved in this project of instigating hate crime legislation in Ireland. And the points made by the previous speakers are important and do points towards an effective regime of hate crime legislation. But I suppose the most important thing that the hate crime legislation ought to achieve is that of a deterrent. Because as Dorian said, we are looking to change behaviors. And of course, I know education is one
rather than take it off. Yeah. Sorry, Bashir, can I interrupt you? I'm told that this would work better as opposed to taking it off. It would work better if you put your headset on. So could you do that, do you think, please?
Okay.
Thank you.
Just I'm not listening through the earphones, you see, but okay, that's fine. Yes, acting as a deterrent, because I think that's by far the most important, because we already have criminal offences, okay, and usually that's the process that hate crime currently goes under, so we don't capture the hate motivation. And so if the offence, and maybe Ciara could speak a little bit about this in terms of what does the bill, or rather the act, envisage in terms of sanctions. And the EU is quite clear that, that the remedies for hate crimes or discriminatory provisions ought to act as a deterrent for future breaches. And while I'm on the EU race directive, I should also mention that just because Dorian was talking about the burden of proof element, the onus shifts to defendants. Actually, the EU provides for that, and it does allow for rules of evidence to be more favorable to plaintiffs in the context of discriminatory provisions, and especially when you look in line with positive action that the EU also recommends we take, and which we have taken in respect to gender, but for disability, race, and other distinct groups, we just haven't reached that stage. And I suppose the importance of deterrence can be made clear. For example, the Ian Wright's case, or we can go back to the case of Paul Barry, for example, in 2001, who assaulted, which was a hate-motivated assault, amongst 6 other men, attacked 2 black men. In 2010, so 9 years later, Paul Barry would go ahead to murder Toyosi Shitabe in another hate crime. That hate crime, that hate element was also not covered. And so the point I'm trying to make with that example is that had the hate motivation been captured in the first instance in 2001, that would have acted as a deterrent for him not to engage again in that hate motivation. And you see this replicated throughout the entire system, not just in the criminal system. In schools, we call it bullying, when in actual fact, it ought to be classified as racism or other discriminatory methods. Okay, in our workplaces, instead of harassment or whatever, instead of racial discrimination, we prefer the more more subtle words of discrimination or bullying. When in actual fact, we need to be outright about the situation. And I know there is that fear of over-criminalization, but to me, that's not even a fear. Rather, trying to be diplomatic, rather I would say that's an excuse almost, because over-criminalization is not a point. The point is that we haven't had criminalization of hate crime so far. And the fact that we've reached the stage where we do need it, I don't think the concern should be of over-criminalization, but of acting as a deterrent in order to change behaviors. Now, it saddens me that it's come to legislation before we can change human behavior, especially in a field so sensitive such as race and biological characteristics that we've no choice of. And I think it's an unfair burden on minority groups to have to go through life without such protections. And then when the protection is coming, there are I suppose justifications being made for why we don't, or why we aren't engaging in a fully comprehensive hate crime legislation. And I think it's important that we are strict in our application, because we need to make that point clear of acting as a deterrent. If one person or 2 persons are in jail or fined a hefty fine, that will send a clear message, as clear as a message, as the courts have previously done, where they say, this isn't hate related, it's just an offense. It will send exactly the same message when you say, this is a hate related offense. We're going to fine you this hefty fine so that you and others won't do it in the future. It's unfortunate that it needs to get to that stage, but I think it's an absolute necessity. So yeah, I think deterrent would be my key principle that I would like to see, and we haven't really talked about that yet. So maybe a few clarifications on that.
Thank you very much, Bashir. Do you think the hate crime provisions outlined already, do you think that they can go towards building confidence between minoritized and racialized groups and state authorities, for example, including the police? Do you think they have the capacity to do that? And perhaps I'll ask you my last question as well at the same time, which is, what difference do you think the legislation as proposed might make to victims and families? So do you think it will help with confidence building with authorities, including the police? And what difference do you think it could make overall?
Very little, if I'm to be brutally honest. At the outset, we would really need to see it being utilized in the courts by the Gardaí in terms of prosecutions and actually recording the hate motivation in the system, on the POS system as well, correctly. And again, ensuring oversight over that, because of course we know that each Garda officer entering the database has the discretion to enter the database. And so again, training, are they aware of the distinct group that this person belonged to? Or is that a matter for the victim to be explaining his own circumstances and his own identity background? So again, I think that's really important. So we have a long way to go in terms of getting minority or ethnic minority groups to trust the system that has for so long neglected them. And so we have a huge building of trust work to do. And that starts with the Gardaí and the relationship with the Gardaí. I know that they have a diversity community, internally, but in terms of practically, we haven't seen the benefits of that, at least. And so what we need more is community engagement, community awareness of our rights, that we can, when the legislation comes to be, that it will be ineffective. Like we've said, we've talked about the 1989 Act. Only 2 convictions from the court services report have actually resulted in imprisonment. Only 2 since 1989. That's not because of a lack of, hate crime in Ireland. We know there's hate crime in Ireland. That's a lack of care in terms of data gathering, data statistics. That's a lack of protection, a lack of trust with the community. How can we trust the people who are supposed to protect us when they're the ones who are racially profiling us, for example? And so when we're talking about hate crime legislation, it's very important also that who is overseeing that, which is why a national action plan against racism is so important, and we don't have that yet. And I think that needs to coincide with the hate crime legislation in order to ensure supervision and training, awareness creation, and things like that, because legislation is all well and good, but how do we entrust people to use it, to be effective? And it's all about trust building. And I think it starts with the very first point of the criminal justice system, and that's the Gardaí. And the relationship there has been broken. And I think it needs to be rebuilt in order for the hate crime legislation to be trusted. Because in order to use the hate crime legislation, there needs to be reports of this. And the only reports we've been receiving so far is from INAR. And so until we get governmental reports putting priority on this issue, because it is a huge priority, Leo Varadkar called it a pandemic last semester. And so last summer rather. And so it is a pandemic, and it's something that we really need to address now and to start building that trust in our communities.
Thanks, Bashir. And just finally, do you think it'll make a difference, just very briefly, and I know you're already expressing some concerns, but do you think, what difference can it make, do you think?
It'd make a difference, I suppose, like any good law, we have a safety net, okay? In the sense that, well, we know it's there. We can rely on it. If it fails, it fails in the sense of, the conviction rate. But at least we have a safety net that we can rely on. Then again, the effectiveness is the crucial part in terms of how effective it is. But I think the importance of it being there, it sends a message that we do take discrimination. We have a zero tolerance, I suppose, for discrimination in this country. And I think that's the message it's sending. That's the message we were sending in 1989. We didn't do it correctly. Now is an opportunity to get those diverse voices, and I know you did a consultation process for the bill, but really in terms of supervision, at least, in terms of supervising the effectiveness of the hate crime legislation, supervising the training of the Gardaí members in using this hate crime legislation, and training the judiciary in understanding hate-motivated offences, because it's not something that they've had to deal with. It's certainly not something that I can't speak for every judge, but by and large, I could imagine that it's not hate isn't something that they've experienced at a close level. And I think it's when we're making decisions on hate crime legislation, we need those voices in there because we have the experience and we are the people who know how this will work. And so it is a good starting point. But what I'm scared of is that this is just another piece of document that says we've ticked the box in terms of our international obligations, and that's it. And so effectiveness needs to be captured by way of effective supervision, and needs to be supervised, and that's the Garda Síochána. We need a supervisory body to make sure that this hate crime legislation does become enforced. So it's a good start, and I welcome the hate crime bill and the incoming legislation because we need it urgently. But in terms of its impact and its effectiveness, that's a whole different question, which I suppose we'll have to come back to after it's been implemented.
Thank you very much, Bashir. And indeed, I'm very conscious that the sort of training that you're talking about is something that's recommended by every regional and international body, including the United Nations ones that Ireland reports to, including training of the judiciary and all concerned with the justice system right throughout the administration of justice, actually. And I look forward to continuing to work with you as another member of the Anti-Racism Committee to ensure that some of the things you're talking about are actually included in the plan that I hope we will conclude over the next number of months. I move on now to Peter Kearns. Peter, yes, I can see you now very clearly. Peter from the Independent Living Movement and also a lecturer at St. Angela's in Sligo. Peter, as a human rights and disabled persons' rights activist, what are your concerns that hate crime legislation should be able to do to protect people, to protect the people that you're concerned about?
So just before I start, I'd just like to apologise for the speech in terms where it can't be cured, it can't be fixed. I've been to lose twice, and I have to accept that can't be changed. So I will always have a Kulak accent. Can't do it about it. Just anybody
Years. Yes, I've noticed.
So is there anything you want to clarification, just give me a show. I think just in terms of this morning, working on Ciara's very good, clear approach to defining how hate crime in terms of a communication between two bodies, you know, between the perpetrator and the victim. In terms of disability, it's my own background in media and cultural studies around disability culture and disability arts. Is that the hate crime itself at that point, like the media, media doesn't change things, it reflects. So the hate crime must reflect a culture and society that the perpetrator carries out in a particular way, like the case that the case that Seamus gave us in the UK, or the two disabled men being spat on by a younger man. So that idea that the point of the hate crime is a crime, but how do we get there? How does the society get to that point? So for disabled people, I think it's interesting for us in terms of how do we prove the hate crime itself? So what do we use? And Seamus is very good in saying the word vulnerable is a problem. It's a big problem. The word vulnerable, because it's very hard to bring a case on the word vulnerable in terms of, and the point of that is that it implies that the word vulnerable for disabled people implies that it's an essence of the person, of the victim. Whereas we like to use the term disempowered as well. So at that point, the point of the attack or the hate crime is a point of because you're vulnerable, or is it because you're disempowered by society at that point. So in terms, that language is hate crime. We are talking about language and actions as well. As Seamus pointed out, that things like robbery, assault, sexual crime, the actions are quite high with disabled people. So the language and the culture that informs that approach is essential. So one way you look at it is that what do you use to prove that language? What do you use to measure that language? And as a disabled persons organisation, something that we've been campaigning since the early 90s, is that using the paradigms, the concepts of the medical model and the social model to prove hate crime as well. So that we don't have much stats here in Ireland, but if you look at the UK stats, the most recent, it's 97% of hate crime against disabled people goes unreported. Most of that hate crime is towards younger disabled people, and most of that hate crime is by younger non-disabled people. So the idea is that the actual action itself, the hate crime action, if we step back on that, how do we get to the younger people? First of all, younger disabled people, how do we build up their capacity to have the confidence to recognise themselves as not vulnerable, but as disempowered, and how to gain power and gain confidence, and especially in association with collective disabled persons organisations, and then look at the perpetrator. What are they reflecting in society? So to give you an example, say the last 2 years myself, something that I haven't come across for a long time, but it's this hate crime. Since the rollout of the dying with dignity bill, myself and my colleagues have come up against a growing number of people saying to us, if I was you, I'd kill myself. So that's only the last 2 years that kind of language is coming out. Is it hate crime? I think it is, but will it be enough to go to court to be a case? That's doubtful. But it's reflection of a bigger media and cultural debate around the value of life, and that is reflected in more and more disabled people encountering this language of how do you why don't you kill yourself? So that's the so in terms of going back to the hate crime young people, is that behind the hate crime legislation, we would like to see, and looking at the Scottish example, there's a really good report called IME Scotland, which looks at how we respond to the hate crime, especially of young people. So the role of disabled people delivering disability quality training in schools and places where youth clubs, places where young people gather. So that idea of disabled people themselves delivering disability quality training and trying to get before the actual act of the crime, trying to give a counter argument against society's response to disability as a problem. So that idea that the hate crime itself is probably more backed up by a response by educating young people about what disability quality is and all. And just on that point, you take the American Disability Act, which has been around for a long time. America, I gave a workshop yesterday to a group of disabled men, and they said they went to America 2 years ago, and they were surprised how America is so backwards compared to disability, even though they had the American Disability Equality Act for years. Well, one example is the filmmaker Clint Eastwood. He had a rank open to the public. He wouldn't provide access. He refused to provide access for disabled people. The disabled activists used the American Disability Act to bring into court. He lost his case, and he was fined, and he had to provide access. But the outcome of that was a film called $1 Million Baby, which won the Oscars for Best Film and won Best Script. And the narrative behind that film is that disabled people want to die. So even though the American Disability Act was used by disabled people to win the actual case, the bigger cultural outcome of the film was the narrative that disabled people really want to die. So I just think, so what I'm saying is that like what Dorian said, is that, well, do we want to focus on the crime, or do we want to look at the underlying ways of how we can tackle people's attitude towards disabled people before they make that decision to make that crime.
Thank you. Thank you, Peter. I think that's a very important question, and one I've heard you raise on a number of times in other contexts too. Just one very final question though to you, and very briefly if I can. Do you think the hate crime provisions we've been discussing here could help build confidence between disabled people and the state authorities, including in particular the Gardaí?
I think if we again, like what you say, we can look at international practice. I think look at Scotland has a really fantastic program called, as I said, IME, which is working with the police, which is a disabled people's organisations working with a particular police unit addressing hate crime. But the IME is focused not on the perpetrator, it's focused on building up confidence of disabled people who encounter hate crime. As I said, 97% of the UK hate crime is not reported. So even though a hate crime provision might be there, there's a good chance that disabled people might not have the confidence to use it. Whereas I think parallel to that, if we build up the capacity of disabled people, especially younger disabled people, and especially younger disabled people working class areas, because nearly 40% of disabled people live in working class areas. So it's building up their confidence to not only report the crime, but also to have a collective space where they can mentor each other and gain confidence to live out the life course. But also in terms of hate crime, how does it take on during point of does it or can it take on how systems such as the DAL or systems such as the HSE response to disability, those systems, do they create the grounds for hate crime too?
Okay.
Yeah, so yeah.
Thanks very much, Peter. You've made that point very clearly about the conditions which are created within which hate crime can flourish. And thank you also personally for mentioning your antipathy to the term vulnerable, which I fully share. As a woman, I'm tired of being told that I'm vulnerable if I walk in certain places at certain times of the day or night. It's the conditions that have created that, not just for many of us as women, but for a variety of groups who are marginalised and minoritized. Now, I'm afraid that I think Owen is still not with us, which is a great pity, because I must say I'm sure, as indeed any of the traveller organisations that were involved today would have been able to speak to, is a certain degree of concern that the 89 legislation might be cited as a good example of things, because I'm very familiar with a number of cases that traveller organisations have taken under that legislation, where to some extent it's the way in which the legislation was interpreted. But I'd have to say in other instances, I know Owen would have been speaking about the limitations of the legislation and the extent to which it wasn't possible under its provisions to afford the protections that should have been afforded. But indeed, in its day, as Ciara pointed out, the fact that travellers were explicitly named in it was something that a number of groups had campaigned for. Now, because we have a small bit of time, I'm going to pass back to the Lord Mayor so that some of the many questions that a number of you have been asking can be put to the panel and that we can hear their responses to them. So, Lord Mayor.
Thank you, Anastasia, and thank you to all our speakers today for giving their insight. It's great to see, and it's great to see the unity in trying to move this forward as well. We have quite a number of questions. We're going to try to answer the majority online, but we are going to bring one or two in now to ask their questions, because we really want this to be as interactive with the audience as possible. And then we'll read some questions out. So I have Gina coming in to ask her a question in person. Gina, are you there?
Hi, yeah, I'm here. Yeah, thanks for inviting me. I was just making a comment there early on, because we talk about all the minority groups, and different areas. And I was kind of wanted to acknowledge the fact that Roma community in Ireland, are going through kind of similar experiences with traveler community. We have a lot of hate crime, you know, towards the Roma community. Very little is talking about or is reported to the authorities because of that prejudice towards the Roma community. We also had a few people that have been literally in the last couple of years have lost their lives due to racism. And just I wanted to bring an acknowledgement, and not to forget, you know, the incident that happened a couple of years ago when Roma children were taken away from their families. If you remember that, in Dublin and Athlone. And I'm very familiar with the situation in Athlone because at the time I was doing the research for Vincent de Paul there. And the family that the child was taken away from them was working with the Department of Social Workers, and the Gardays were, you know, knew the family for years, and they knew that that child is their own child, and yet the child was taken away from them, the boy, you know. So I think, in my opinion, it's very important to acknowledge the fact that, you know, the Roma community really suffers, you know, racism. It's going to, we can talk about intergenerational trauma. This is nothing new to them. This has happened for hundreds of years, and it's literally disappointing that in this day and age, you know, their experience is same problems on par with the traveler community. And traveler community, it's true, you know, they're indigenous people, that they're here for as long as Ireland has been here, you know. So I just wanted to bring that acknowledgement.
Thank you so much, Gina. And I know Pavy Point will absolutely agree with you, as well as other advocacy groups. They have been pushing this for a while in relation to discrimination against Roma and traveller community. So thank you so much for your comment. I'm going to bring in Christine now, who I think has a specific question for one of our panelists. Christine, are you there?
Yeah, Christine.
Christine, yeah. This is like Eurovision, guys, except so.
Hi.
No.
Hi there.
Hi, Christine.
Hi. So I'm at the moment doing my research on hate speech. So in UCD. So I brought in my research proposal, and my supervisor was telling me that you have to look into the debates, and there's no bill at the moment, but it's coming forward. So my focus is on hate speech rather than like the hate crime, but he told me that I could use like the hate crime, this new hate crime bill into it. So I was wondering, is hate speech alone, so like, you know, shouting racist abuse at somebody, shouting it online, putting racist material on you know, like through your door, like what happened with George and Kensho. His family received a letter full of racist abuse, and he said that they might have to leave their house if they keep on getting more of these letters. So I was wondering, is that alone an offense that you can be fined, or if you can be fined or even put in jail for?
I'm going to bring Ciara Carberry in, since she is the principal officer from the Department of Justice looking at this new legislation coming in place. So Ciara, with Christine's specific examples, and I think in what she is asking there, can you give her some insight?
Yeah, I mean, obviously, subject to the caveats I mentioned earlier, the law has to go through the Oireachtas, it has to be finalised, and it is all subject to change. When people talk about hate speech, they talk about two different things in my experience. They're talking about incitement to hatred, and incitement to hatred means where somebody sets out to stir up, I suppose, harmful negative feeling about somebody or about a group because the person doing the stirring has a problem or has a prejudice against that group. So Christine, I don't think that's what you're talking about. I think what you're talking about is the other type of hate speech that people talk about, which is where it's aimed directly at a person. So you're not trying to stir up as an audience as such, but you are directly harassing or intimidating or coercing or trying to coerce a person or a family because of a prejudice against a protected characteristic. So harassing and coercing and intimidating people is already a criminal offence if it's serious enough. And the new legislation hopefully will introduce a new form of that behaviour where it's aggravated by hate. I know that's a slightly complicated answer, but I hope that answered your question to some extent. And again, this is subject to the legislation going through the process, but there should be a recognition that harassing somebody because they are a different ethnicity or because they are a different sexual orientation or whatnot is a more serious form of that offence.
Thank you so much,
Thank you,
Ciara, and thanks, Christine.
Thank you.
I'm good. Thanks, Christine. I'm going to also, Christine, thanks for all your good work. I see you online constantly talking about this issue, and this is what we need more of. We need more advocates. We need more people talking about this and have an open discussion on the issue of discrimination and seeing how we can tackle it. I think we can only tackle it through unity. I'm going to move on to Maria, who I'm very conscious, as Anastasia pointed to, that since Owen cannot be here, that we would really like to hear from a viewpoint from a traveller community. So I'm going to bring in Maria Joyce. Maria, can you hear me? And
yes,
she has
and
a question,
I hope
a comment.
You can hear me because I'm having some. I hope you can hear me. I'm having some problems with my Wi-Fi. Can you hear me?
We can hear you.
Okay, and I suppose I'll be brief, but I just want to echo the point that was made around the lack of feeling and certainly the reality of it was protection from the 89 legislation, and I suppose my couple of questions were focused around the real need to ensure that the new hate crime and hate speech legislation will ensure real outcomes and justice that it addresses the particular experiences of racism, hate and stereotyping experienced by travellers. And in terms of traveller women, like other ethnic minority women, experience multiple barriers due to the intersectionality of ethnicity and gender. I think it'll be really important that the legislation addresses that in a real way. Because certainly for traveller women around the country, it certainly is, and it feels like the situation is getting worse in terms of the everyday forms of racism. And we've seen in more recent times, it's not that it hasn't always been there, it has. And certainly I welcome those comments earlier from a number of speakers in terms of racism is not new to Ireland. Racism in terms of travellers' experience of racism has gone back multiple decades. But we have seen more of a rise in some areas in terms of politics, in terms of the online. And certainly one of the other points I was trying to make as well in the questions is that, if you are going to address societal and try and change the everyday behaviour of racism and the particular experiences of traveller women and other ethnic minority groups and people with disabilities and all of those under the categories for this. Long-held institutional racism needs to be held to account and needs to be addressed, because societal behaviour is not a standalone, and it has happened and it keeps reoccurring because of the institutional racism and because of the lack of being able to be held to account. And I think the point I was trying to make in education as well is that, the impact that does have on the institutional racism on children and on traveller children, and the need to address that. And the one final point I'll make is that having legislation is absolutely crucial and so important, but having access to that justice is equally important. And in terms of and not all people affected by hate and racism will have equal access to justice. Because even for travellers trying to access legal representation, they're coming up against significant racism and bias. There's areas in this country where solicitors will not take on travellers as clients. So access to justice will be really important. And this legislation does need to look at that aspect of this as well, in terms of resources and in terms of targeted measures and special measures to ensure those most marginalised and most excluded and who experience racism and hate, not just on the street or in shops, but even by the institutions that are there to protect. And I'm also in the context of, I welcomed comments earlier as well around the racial profiling and the need to address the particular issues within the Gardaí, because we have seen time and time again where racial profiling is happening in the context of travellers and Roma in this country and other groups. But we've also seen where, Gardaí have, in how they've put out sort of, the fact that also the Gardaí aren't reflective of the community it serves is a really important thing. And I think, in terms of that, because what you want is as much of a collective impact from, of course, hate and racism is a very personalised thing when it happens on the street, but in terms of institutional racism, and it's collective in its sense when it attacks an entire group, and having that addressed will be crucial, and having access to that justice so important.
Thank you so much, Maria. And Maria Joyce is from the National Traveller Women's Forum. Maria, thank you for joining us today on this, and thank you for all your hard work. I know from working with different colleagues like Eileen Flynn and Rosemary Maughan, there is a huge amount of advocacy work within the traveller community, but there needs to be more work done from our side in terms of the policies that can help and to make sure we fight discrimination. I'm going to bring, sorry to the panelists that I keep on bringing Ciara back in, but because the legislation is within her department, that I will bring her back in to address Maria's concerns before we move on then to Brigitte and Anastasia's interview with Brigitte, and then we will move on to wrap up and answer some more questions at the end before we wrap up. Ciara?
Thank you very much. I think that Bridget's contribution is really important because it highlights the fact that the criminal justice legislation on its own, it can be a cornerstone, it can be, it provides, I suppose, the hard line where if you cross this line, the full coercive power of the state will be brought to bear on your behaviour. For that reason, as Darren was pointing out earlier, we have to be very, very careful about where we draw that line, and we have to be very clear that the criminal law is the measure of last resort. I think Bashir and Peter both made really good points about deterrence, and I think that Bridget's contribution highlights this as well, because the end game we are trying to get to is where when people think about doing something like this, whether it's in the sphere of hate crime or hate speech, or whether it's in the much wider sphere of discrimination, that they don't do it. That's what we want. We want them not to do it. So what makes you not do it? Well, there's quite a lot of evidence in the criminal sphere generally that the best deterrent is not a harsher penalty necessarily, although it is intended that the new legislation will provide for enhanced penalties. But the deterrent that seems to stop people is they stop and they go, if I do this, I am likely to be caught, I am likely to be prosecuted. So it's the likelihood of a penalty. It's the likelihood of something unpleasant happening to you if you do this. So there are all kinds of measures in that mix that we need to deploy. The criminal law is certainly one of them for the most serious cases, but there's a huge amount of power in wider society to deal with these issues. Codes of conduct were mentioned, education was mentioned, awareness is mentioned. I know the anti-racism strategy is looking very seriously at all of these, but we need to change the the atmosphere around this type of behavior so that people know that if they do this, it will not be acceptable. It's not good enough for people to pretend it isn't happening anymore. We know it is happening. We know it's happening across a whole spectrum of behaviors. So how do we make sure that it isn't tolerated generally? And that will make it less likely for people who are inclined in that way anyway to indulge their own prejudice outwardly in a way that harms people. And whether that's, you know, sporting organizations saying, if you're a member of our organization, you will not behave in this way, or you will be in breach of our code of conduct, or whether it's a code of conduct for lawyers, or whether it's a code of conduct for civil servants, or, you know, across society, we need to see that community level of response where there's an agreed set of values, and behaving in a way that discriminates against people or harms them is a breach of those values generally, and that's accepted. Part of that, of course, is that we have to bring in measures that people can trust and buy into, not just in affected communities, but sort of reasonable people who maybe are more likely, because they've never encountered hate speech or hate crime, to put themselves in the shoes of the perpetrator than the shoes of the victim. That is a very serious problem. That people, when they hear about a scenario, they go, oh, but I could be falsely accused of being a racist, so we need to be very careful. You know, we just need to make sure the law is sound and workable, and that everybody can trust it to the greatest extent that we can. Of course, we're not going to get it 100% right on the very first try, or well, maybe we will. I'd be delighted if we did, but we have to be humble enough as well to recognize that we're going to have to mold it and shape it over the years as problems with it become apparent. I hope that deals with some of the issues. The reverse burdens as well, I might just mention very quickly, there's no intention of a general reverse burden of proof at all in there, just in relation to certain types of things that the court will be allowed to presume. So for example, if you were to paint a swastika on a Jewish person's house, that you couldn't say that you didn't know it was a swastika, or that you didn't know what a swastika was, or you didn't know what it meant. It's those types of things the court can presume. If you paint a racial slur on a house, that you knew it was a racial slur. It's at that level. It's not at the general burden of proof for the innocent or guilty. Sorry, I know that went on a little bit.
No, absolutely. This is the thing. This is a discussion we need to have, and we're going to have ongoing ones, because, as you say, Ciara, I think there's a lot of there will be room for improvement, because as things develop, we need to assess, and this is why data is important as well, and why I love that INAR is gathering that data, is because we need to be able to see how it affects people, and then be able to see how the legislation can help and support people. I'm going to move back on to Anastasia now, who will be doing a 10-15 minute interview with Bajit Uvaid, from Director of Policy and Strategy at the Crown Prosecution Service for England and Wales. It's to give us an idea of how this works in other jurisdictions, how it is working or isn't working, and how we can learn from it. So, Anastasia, I'm going to move you back.
Thank you. Thank you very much, Hazel. Thank you, Lord Mayor. Before I talk to Baljit, and which is, I think, for whom a number of questions have been gathering during the morning, I hope you've been able to join us for some of them, Baljit. I would just like to say a couple of things. First of all, thank you very much, Gina and Maria, for your comments about Roma and travellers. There's absolutely no doubt but that Roma and travellers experience a very particular form of racism and a very particular form of hate crime, not just in this country, but in every other country where I've had the role or the task of reviewing the discrimination that Roma and traveller experience. So thank you very much for your comments. I think what they do is make it very clear to us about other things that have been mentioned here as being essential to address, and that is the systemic structural racism that people face, which, as Bajir very rightly point out, isn't just got to do with individual bullying, but is reflected in our institutions, and then, of course, visible also in the experience of individuals. So thank you for taking us along that road and for making it very clear that alongside legislation, other measures are needed. But I think we remain very firmly of the position this morning and very clear in the view that the state has the overall responsibility, and one of the key responsibilities we're discussing here this morning is one that the state has taken action on, which is to begin to shape more comprehensive hate crime legislation that can address some of the fundamental issues that a number of you have been discussing discussing. So with that in mind, what I would like to do now is to turn to you, Baljit. You've been listening carefully to a number of comments that have been made about legislation elsewhere, and indeed a number of comments that have been made about UK legislation and about the things that we might be able to learn from it. Maybe my first question would be to ask you to tell us about the UK hate crime legislation, about how it works, and about what you, in your role as Director of Policy and Strategy at the Crown Prosecution Service, what you can say about its key strengths and areas where you think your legislation might be strengthened.
Thank you, Anastasia. It's an absolute privilege to be here and to talk about the experience in England and Wales. I think the first thing to say is that we don't have one statute covering hate crime in England and Wales. So what's happened is the legislation has sort of developed piecemeal over the years. And so the fact that you're sort of looking at this now from an Ireland perspective, it's a huge opportunity to take a much more sort of considered and holistic approach rather than what's been quite an evolutionary approach, which has meant that there isn't an equitable, I would say, protection for all protected characteristics is one of the things. You know, asking me the question about from a policy strategy point of view, you know, what maybe doesn't work as well is because it has evolved ad hoc over time. It is inconsistent. So in terms of the sort of broad legislation that kind of covers hate crime in England and Wales, the first area is around the Public Order Act of 1986. And that talks about sort of stirring up hatred on the grounds of race, religion, and sexual orientation. And those are sort of rare offences. The bar is very high. They are prosecuted by specialist teams and can only be prosecuted with the consent of the Attorney General, who is the minister who has superintendence for the CPS. So we do prosecute, but that is not common because of the high bar in relation to stirring up hatred. More common is the Crime and Disorder Act of 1998, and what that created were specific offences for racially and religiously aggravated offences. Now, what they did is they took existing offences around assaults, criminal damage, threatening and abusive behaviour, and stalking and harassment, but said that you had an aggravated form where it was done on the basis of race or religion. And then there's obviously a test around how how do you define that? And certainly in the UK, the test of demonstrating that it's an aggravated offence is done on the basis of hostility, and that can be motivation of hostility or demonstration. And I can say a bit more about that if that's helpful. And then we also.
Sorry, go on. Since that's one of the areas we have been discussing actually, and I'm a bit conscious of the time. I think it would be helpful if you said a little bit more about that just now, please. Thank you. Yes.
Brilliant. Okay. So if I talk a little bit about that, then, so what we have to demonstrate is that at the time of committing one of those offences, or immediately before or after doing so, the offender demonstrated towards the victim hostility based on the victim's membership or presumed membership for one or more of the protected characteristics, and or the offence was motivated wholly or partly by hostility towards members of one or more of those protected strands. Now, demonstration of hostility, what does that mean? That can mean evidence of words, and they can be spoken or written, or actions that show hostility towards the victim. So I would say that this is by far the vast majority of our cases is based on demonstration of hostility. There was a case in 2007, R.V. Rogers, and the defendant was involved in an altercation with 3 Spanish women, during the course of which he called them bloody foreigners and told them to go back to your own country. And the House of Lords, in upholding the defendant's conviction, this was actually dealing with a racial group, said that the definition of a racial group clearly went beyond groups defined by colour, race or ethnic origin, and it encompassed both nationality and national origins. But what we didn't have to do there was sort of get behind the motivations. So, for example, targeting religious clothing, pulling off a hijab, in a disability context, pulling away a walking stick or tipping a person out of a wheelchair. Sadly, we've had examples of hate crime, disability hate crime cases where that has happened. That would all be treated as demonstration of hostility. And what's important about this is that the prosecution is not required to prove any element of hate-based motivation. And so I thought I'd share with you just an interesting example. Although this was an unsuccessful case, it's a really important point. You may recall when the footballer John Terry was accused of racially abusing Anton Ferdinand. John Terry was saying, well, I'm not a racist. We did not have to prove whether John Terry was a racist or not. All we had to prove was that he used racially derogatory language. Now, unfortunately, the district judge in that case could not be sure what John Terry had actually said, so we didn't get a conviction. But you can see how sort of getting into the heads of someone, if you're just looking at motivation by hostility, would be problematic. So I think it's fair to say that from our perspective, the demonstration of hostility limb is really crucial in enabling the courts to recognise the additional level of harm that this causes to victims, whilst not having to try and understand the underlying ideology or motivation of an offender or suspect. So, I mean, but what I would say is our legislation has demonstration and motivation. And so there are also scenarios where if you only had demonstration and didn't have motivation, that would also create a gap. So for the motivation, again, what we would need to sort of demonstrate the aspects that I'd mentioned earlier. But we did have a case which shows where the gap could be, where there was an Orthodox Jewish man who was wearing sort of distinctive religious clothing, and he was the subject of a completely unprovoked street assault. The attacker said nothing at the time, so we couldn't show demonstration of hostility. However, the police were able to track him down, and when they went to his home address, they found his collection of Nazi memorabilia and anti-Semitic literature. And so in that case, we were able to say, here's a motivation of hostility. So even though motivation is significantly harder to prove than overt demonstration of hostility, and does require a much more in-depth and thorough police investigation, which obviously has impacts on police resourcing, CPS resourcing, it's still a useful limb to have for that kind of case. And what I would say from my experience of dealing with hate crime cases for many years is sometimes people can be quite subtle and nuanced in the way that they commit these offences. So you have a spectrum of the very kind of reckless, saying things to people, to a very sophisticated approach. And I would suggest that you would want to shape your legislation in a way that can address that broad spectrum hate crime offending. So that's the difference really between motivation and demonstration. And as I say, the majority of hate crime cases in England and Wales are based on the demonstration of hostility test.
Thank you. I'm very sorry, Baljet, that we haven't more time to speak with you, because I think what you're saying resonates and raises a number of other questions and comments I know people would like to make. And I'm also very sorry not to be able to take more questions and not to be able to return to either Seamus or Darren or Peter, or Bashir or Peter. And I'm sorry that Owen wasn't able to join us, so my apologies to all of you for that. By way of just at this stage concluding, before I hand back to the Lord Mayor, it seems to me that this morning we've been very clear that legislation, broad legislation, legislation that covers a broad spectrum in this field is absolutely essential. We've been clear as well that one size does not fit all, and people have spoken quite a lot about that, about the particular realities of hate crime for different groups, for travellers and for Roma, for disabled people, for a variety of other groups in society. The sort of intersectionality with racism, institutional systemic racism, and the way that works. We've also spoken about the need to consider freedom of expression and the importance of creating conditions where that can be maintained. And then we have moved to consider also demonstrating motivation and also demonstrated motivation, and the importance maybe of looking to ways that can combine the broader spectrum of tests which can actually ensure that this legislation, reflecting some of the comments that were made earlier, actually is able to secure convictions, and convictions that, as Bashir put it, create the conditions for a very different sort of society. We've also been clear that legislation on its own, and these are comments that have come also from all of you on the panel, isn't enough, that other measures are required, measures against racism, measures to create the conditions for a society in which people are treated equally, in which disabled people are treated equally, as indeed Peter pointed out to us. And we have called for a variety of things. People have spoken about a variety of things in that regard. Finally, I could say we seem to be saying a lot of work done, but much more to do. And I look forward personally to working with all of you in order to secure that. Lord Mayor, I'd pass back to you. And thank you very much to you on behalf of all of us, and to all who've been associated with this morning, with all of the logistics that go into it, for creating this opportunity, which I think has been a really useful one.
Thank you, Anastasia, and thank you for, I've heard of your amazing work in the UN and now on the Anti-Racism Committee. And thank you to all our panelists here today. I'm sorry that, as Anastasia said, we didn't have more time with everyone. We will be having an afternoon session as well to talk to An Garda Síochána and also INAR, and also various, and the Immigration Council, and various members of society as well, to bring in their questions like earlier on, but we'll be taking a lot more in the afternoon session to talk about people's experiences and to talk about how reporting happens and how we need to do better in terms of the reporting side of things and the support side afterwards. But on this particular morning session, I guess what Bashir and Peter said really hit home. Like, there's a lot to this, that this is the enforcement side, this is the stick side, and there has to be a carrot as well approach to this. There has to be a unified way of working in terms of making sure that we are educating from a young age what discrimination would be and what it looks like, and how diversity needs to be celebrated, not to be feared, and moving then onwards towards campaigns during college years and civil society campaigns, because there's a lot here that we need to look at the as I said, the education and celebration side, and then look at the enforcement and protection, because the protection and true enforcement should, as Bashir said, be a safety net. It is the last resort that we want to have, to make sure we have it there to protect people, because it shouldn't get to the stage where people are facing these abuse and facing assaults or crime of this nature. So, and we need to build a society that prevents that rather than gets to a stage where we need to enforce it. So on that, I also have various comments here from people, really interesting ones. We'll try to tackle them on the site itself in the INAR site to answer some of these questions. A lot of them talk about institutional racism. I know the Gardaí were pointed to. We'll be discussing it with them later on today. But the need for a firewall to protect people without documents who have been target of hate crime as well. So these are all ideas that we'll be bringing forward to the department through INAR and different groups. And again, thank you to the department for coming today. Thank you to all our guests today. Seamus, Duran, Bashir, Peter, Bajit, Ciara, Duran, and again, Anastasia as well, Shane O'Curry, and the guys here at DV4. On a last closing note, I guess, on a very personal note, like a lot of people ask, well, why are we talking about it now? Because we are at this intersection where we can be driven by the rhetoric that's being pushed by a minority and become an even more divisive society, or we can try to unify and have cross-collaboration. I noticed my council colleague, Alison Gilliland, putting a comment there that it needs to be cross-community, cross-society, that there needs to be training there. And that's what we need to do. We need to have these open conversations. And I welcome that there may be dissension from these conversations, but we need to be able to have them. And we need to be able to be transparent and hold our hands up and say, yes, this is the issue and we're willing to tackle it. I'd like to thank all of you and the audience, from myself and my family, for your support this year. But I think one of the things we really need to see is how do we do better and how do we provide solutions. So again, thank you for coming here to discuss it today. We'll be discussing more in the afternoon. Massive thank you to Anastasia again, and I look forward to seeing you all in the afternoon session. Thank you.